If you hold a United States passport, if you have a green card, or if you're currently going through the immigration process, what we're talking about today matters. Because despite what many people assume, there are real legal situations where American citizenship can be lost, and the way this works is often misunderstood. My goal with this video is not to create fear or panic. It's to give you accurate information so you can move forward with confidence. When you understand the rules and the process, you gain clarity, and clarity takes the power away from anxiety. My channel name is Policy and Pathways, and thank you for trusting this channel as a place to learn about complex immigration topics. Citizenship law, visa processing, and policy enforcement continue to evolve. New interpretations come out. Court decisions change the boundaries. Administrative priorities shift. And in the middle of all of that, real people are just trying to understand where they stand. Today, we're going to walk through the real mechanisms that can impact citizenship, who they apply to, what the government actually looks for, and how these cases unfold in real life. We'll also touch on broader immigration updates that affect applicants, families, professionals, and students. Let me be very clear from the start. Nothing I share here is legal advice. I'm not an attorney, and I'm not speaking on behalf of any government agency. What I'm offering is research, clarity, and perspective, presented in a straightforward way that respects your intelligence and your need for honest answers. A lot of people believe that once citizenship is granted, it becomes permanent in every possible situation. You receive your naturalization certificate, you get your U.S. passport, you vote, you feel like the journey is finally complete. And for the overwhelming majority of naturalized citizens, that sense of security is absolutely justified. But the legal reality has nuances that are worth understanding. U.S. citizenship is one of the most secure legal statuses in the world. It comes with constitutional protections, powerful rights, and strong safeguards. Still, under specific conditions and through defined legal procedures, the government can revisit a citizenship case. That does not mean federal authorities are out looking for random reasons to strip people of citizenship. It means the integrity of the naturalization process is taken seriously, and the rules for obtaining citizenship must be followed truthfully and completely. Before we talk about the ways citizenship can be lost, it helps to clarify who is a citizen in the first place. Some people are citizens at birth. They're born in the United States, certain U.S. territories, or they are born abroad to parents who can transmit citizenship under the law. Others become citizens through naturalization. They weren't born American, but they entered the U.S. through lawful channels, maintained lawful status, met residency requirements, demonstrated knowledge of English and civics, and took the oath of allegiance. Both groups, citizens by birth and citizens by naturalization, have the same fundamental rights and constitutional protections. But there is an important distinction in how citizenship can be examined later. For people who acquired citizenship at birth, that status is extremely secure. In almost all situations, it cannot be revoked except in extraordinarily rare cases involving identity fraud or falsified birth documentation at the very beginning. For naturalized citizens, there is a detailed administrative record. Applications were submitted, interviews occurred, background checks were completed, biometrics were taken, and if evidence later emerges that a key part of that process involved intentional deception, especially deception that would have changed the outcome, there is legal authority for the government to challenge that naturalization. This does not mean minor errors lead to citizenship loss. It does not mean confusion, language barriers, or honest mistakes automatically put someone at risk. The standard generally focuses on intentional and material misrepresentation or deliberate concealment of facts that matter to eligibility. As you listen to the rest of this, hold on to one central truth. The vast majority of naturalized citizens never face any challenge to their citizenship. The cases that do arise usually involve serious fraud, major criminal concealment, or conduct that directly conflicts with the oath of allegiance. These cases are not routine. They are exceptional, and they receive substantial legal scrutiny. Let's start with the most straightforward way citizenship can be lost, because this one is fully voluntary. It's called renunciation. Renunciation is the formal intentional surrender of U.S. citizenship. It does not happen by accident. It doesn't happen because you moved abroad, posted something online, or said you were angry about politics. Renunciation is a structured legal process, and it must be done in person at a U.S. embassy or consulate outside the United States. You meet with a consular officer. You complete specific paperwork. You're informed of the consequences. You take an oath confirming you understand what you're doing and that you are choosing it freely. There is also a substantial fee, and once it's done, it's considered final. Renunciation is not something you casually undo. People renounce for different reasons. Some have built permanent lives elsewhere and no longer identify as American. Others focus on financial issues, including tax obligations that can apply to U.S. citizens living abroad. Some choose renunciation for deeply personal, political, or philosophical reasons. But the key point is that renunciation is a personal choice. No one forces you to do it, and it doesn't happen automatically. When someone renounces, they give up the right to vote in U.S. elections. They lose the automatic right to enter the United States. They may need a visa in the future if they want to visit. For most people, renunciation never becomes relevant. It is uncommon, deliberate, and thoroughly documented. And I want to emphasize something clearly, because there is so much misinformation about this. Living outside the United States does not make you lose your citizenship. Holding dual citizenship does not automatically threaten your U.S. citizenship. Spending years abroad does not equal renunciation. Renunciation happens only when you intentionally complete the formal process. Now we get to the category that makes people uneasy. So I want to approach it carefully and responsibly. Yes, the U.S. government can revoke citizenship under certain circumstances, but it is rare, and it is governed by strict legal standards. This process is called denaturalization, and it applies primarily to naturalized citizens. Denaturalization generally comes into play when the government discovers that a person intentionally misrepresented or concealed material facts during the naturalization process. Material means it mattered, meaning it would likely have affected the decision to grant citizenship. Examples can include using a false identity, hiding serious criminal history, concealing certain activities or affiliations that would have affected eligibility, or giving false testimony about key requirements. Even then, citizenship is not taken away instantly. This is not a secret or immediate process. The government must typically file a civil case in federal court. The person receives formal notice. They have the right to legal representation. They can respond, present evidence, and fight the allegations. A federal judge ultimately decides the outcome based on the evidence and the legal standard. So, while the idea sounds scary, the process itself includes safeguards, time, procedure, and judicial oversight, and context matters. Most people will never face denaturalization because most people went through the naturalization process. Honestly, even if paperwork was stressful, even if English was difficult, even if small mistakes occurred, the legal focus is on deliberate, meaningful deception, not innocent confusion. Another point that surprises people is that there is not always a strict time limit that prevents the government from reviewing an old naturalization file if serious evidence of fraud appears later. But that does not mean authorities are constantly combing through records trying to revoke citizenship over technicalities. It means citizenship is treated as a status of enormous importance, and the government reserves the ability to act if citizenship was obtained through major fraud. If you applied in good faith, told the truth, disclosed what you were required to disclose, and answered honestly, you have strong reasons to feel secure. Next, let's talk about a category that often gets distorted online: affiliations and activities after naturalization. In very specific and extreme situations, citizenship can be questioned when someone becomes actively involved with organizations that are explicitly hostile to the United States or that advocate the violent overthrow of the U.S. government. This is not about peaceful protest. It is not about having opinions. It is not about criticizing policies. It is not about religion, culture, ethnicity, or community membership. The issue is intent and active alignment with groups whose stated objectives involve violence, force, or subversion against the United States. Historically, in rare cases, individuals have joined extremist movements, supported hostile foreign powers, or engaged in conduct tied to national security threats. When that happens, the government may examine whether the oath of allegiance was taken sincerely. Sometimes, if extreme conduct happens soon after naturalization, the government may argue it reflects the person's true intent at the time of applying. But I want to pause and make this unmistakably clear. This does not apply to ordinary people. Living ordinary lives. Living abroad does not trigger it. Visiting your home country does not trigger it. Having cultural ties does not trigger it. Even strong political opinions do not automatically create risk. These laws exist for rare and severe situations connected to violence or genuine threats, not for everyday citizens who work, study, raise families, and contribute to their communities. So, if you see dramatic headlines, take a breath and look for the real context. Was there violence? Was there intentional harm? Was there serious fraud? Most of the time, the context explains why action was taken. And most of the time, it has nothing to do with normal people. Now, let's talk about dual citizenship because this is one of the most common sources of confusion. Millions of Americans hold citizenship in two countries. Some were born abroad and later naturalized in the U.S. Others were born in the U.S. and also inherited another citizenship through their parents. In general, the United States allows dual citizenship. Having two passports is usually not a problem. You can travel to visit family. You can keep cultural connections. You can have a life that bridges two places. For many people, that's normal and meaningful. However, there are rare scenarios where dual citizenship can become legally complicated. Usually, it involves taking certain official actions that may indicate an intent to abandon U.S. citizenship, like accepting a high-level position in a foreign government, especially one that conflicts with U.S. interests or taking an oath of allegiance that explicitly rejects loyalty to the United States. Even then, it's not automatic. The legal focus is typically intent. Did the person actually mean to give up U.S. citizenship in a legally meaningful way? Simply renewing another passport, owning property abroad, or voting in some foreign elections usually does not result in loss of U.S. citizenship. The question is whether the person intended to relinquish U.S. nationality. So if you hold dual citizenship, you can breathe. For most people, it creates no problem at all. Another topic that gets sensationalized is treason and acts against the United States. This is the most extreme and rare category. In exceptionally limited situations, someone could face criminal prosecution and potentially loss of citizenship connected to serving as an agent of an enemy, supporting armed insurrection, or committing serious acts of treason. These cases involve major investigations, substantial evidence, and lengthy court proceedings. Nothing happens quickly, and nothing happens in secret. There are strong legal protections. And for almost everyone watching, this will never be relevant. Studying abroad, criticizing the government, disagreeing with policies, speaking online, or having emotional reactions to world events does not equal treason. Now, I want to address people who were born in the United States because rumors cause unnecessary fear. If you were born in the U.S. or in most U.S. territories and you became a citizen at birth, your citizenship is extremely strong and constitutionally protected. In almost every circumstance, it cannot be taken away because you traveled, lived abroad, made mistakes, or because a family member had an immigration issue. The only extremely rare exception involves fraud at the origin, like falsified birth documents, fabricated identities, or organized schemes where records were created to show a U.S. birth that did not actually happen. These situations are rare, difficult to prove, and usually connected to large fraud operations, not normal families. So, if you were born in the United States, your citizenship is not fragile. It does not disappear because of online rumors or misunderstandings. Now that we've covered the uncommon scenarios where citizenship can be questioned, let's shift to something that affects far more people every day. The immigration process itself, visa timelines, green card processing, interviews, travel rules, and the stress families and workers experience while waiting. If you're currently waiting on a decision, I understand how draining it can feel. You check your case status, you refresh your email, you hear different stories from friends and social media, and it gets confusing fast. That's why I try to explain things clearly without exaggeration and without panic, so you can understand what's normal and what deserves attention. Across many categories, USCIS is still managing backlogs that built up over several years. Some cases move faster than expected. Others take longer than posted estimates. For example, certain employment-based filings and work authorization cases in some locations have improved, while family-based petitions in high-volume areas still experience delays. In most cases, this does not mean something is wrong with your file. It often means your case is in a queue, waiting its turn through a system processing thousands of applications. When your status says case is actively being reviewed, it often means exactly that. Your case is in progress, and when you see no update for months, it can be frustrating, but it is often still within normal processing ranges. The best approach is to stay organized, watch your online account, and respond quickly if USCIS asks for additional evidence. Comparing your timeline to everyone else's often creates unnecessary stress because every case has different variables. Employment visas like H-1B, L-1, and related dependent categories remain in high demand. When demand is high, processing can feel slow. Some applicants get faster decisions through premium processing. Others wait due to background checks or administrative review. Delays do not automatically mean denial. Sometimes they simply reflect additional verification. For students on F-1 visas, planning ahead is everything. Schools, embassies, and USCIS all operate on timelines that must line up. Staying enrolled full-time, following program rules, and staying in contact with your designated school official can prevent many avoidable problems. For B-1, B-2 visitors, consular officers and border officers generally want clarity. They want to see a clear travel purpose, strong ties to your home country, and honest, consistent answers. There's no perfect script. The best approach is truth, preparation, and calm communication. For families, the process often feels personal because travel is tied to weddings, emergencies, reunions, and major life moments. Sometimes interviews are delayed. Sometimes documents must be resubmitted. Sometimes plans change. In most situations, these delays are procedural, not personal punishment. Patience, careful responses, and avoiding panic-driven decisions usually helps more than anything else. When it comes to green cards, this process represents stability for many people, but it can be long. Timelines depend on the category, the applicant's country of birth, and the field office or service center. Some people get interview notices quickly. Others wait longer than expected. Both can be normal. Employment-based categories also shift throughout the fiscal year as visa numbers open, pause, or retrogress. That movement can be discouraging, but it's how the system manages demand under legal limits. It doesn't mean your goal is gone. It often means the timeline changed. Interviews are another stage that creates anxiety. Many people fear saying the wrong thing, but interviews are typically meant to verify information and confirm consistency between the paperwork and your answers. Officers often ask about relationships, jobs, addresses, immigration history, and biographical basics. Honesty is always safest. If you don't remember something exactly, it's better to say you're not sure than to guess. If USCIS needs more proof, they usually send a formal request for evidence. That can be frustrating, but it's common and not automatically a denial. Travel is another major concern, especially with pending applications. Before you travel internationally, it's important to understand whether your status allows you to leave and return. If you're using advanced parole, or you have a pending benefit that affects travel, follow the rules carefully. Carry your documents, allow extra time, and be prepared for routine questions at the airport. Officers typically want clarity and consistency. If you're visiting the U.S. temporarily, the same principle applies. Be honest about your purpose, show ties to your home country, and make sure your plans match your visa category. Sometimes travelers are sent to secondary inspection, which can feel intimidating, but it is often routine. Officers may need to verify something in the system or review prior travel history. Staying calm, respectful, and cooperative usually makes a real difference. As we close, I want to return to the core message of today's discussion. U.S. citizenship is powerful and deeply protective. Yes, there are specific situations where citizenship can be lost, but they are rare, highly defined, and usually connected to intentional fraud, serious deception, or extreme conduct that directly contradicts the oath of allegiance. For people who followed the rules, told the truth, and built their lives with integrity, citizenship is secure. Awareness is useful. Fear is not. And for those going through the immigration process, visas, green cards, travel, or naturalization, yes, it can be long and confusing. Timelines shift, rules can change, interviews get delayed, notices arrive unexpectedly. Feeling tired, impatient, or overwhelmed is normal. What matters most is staying informed, staying honest, and staying organized. If this video helped you feel more informed or more at ease, I'm glad. If you want more updates about U.S. immigration, citizenship, visas, and travel, subscribe to Policy and Pathways. And if you found value here, share it with someone who needs clear, calm information instead of rumors and panic. Thank you for your time and your trust.